Happy to be here today to talk to you a little bit about workers' comp. What I'm going to try to do quickly is to give you a little backdrop on the history behind one of the struggles in workers' comp, which was one-way attorney's fees from a practical perspective, and that is what was going on early in the process, how the legislature attacked it, and quite frankly, it did what legislators don't believe we can do. It brought rates down. So in any event, the workers' comp statute back prior to 2003 was getting out of control. It has an attorney's fee provision in it. You secure benefits, you get a fee. It's a one-way attorney's fee. It had a schedule, a percentage schedule of what you secured on benefits, but it also had a deviation that was allowable by the judge. And the history became that that's where everybody went. The system became an hourly fee system. And so that drove claim cost, it drove rates, it got to the point that it was not sustainable, and that was recognized as well by Governor Bush in 2003. Now, there were a couple battles earlier than that in 2001 and 2002, but I can assure you when you look at some of these graphs and you can see for yourself how effectively eliminating the incentive in workers' comp, it was hourly fees, and the effect that it has on not only reducing litigation, but reducing rates as well. So I have some slides just because graphically it's easier to see than for me to tell you percentage drops in petitions, et cetera. So just one thing, petitions are the way you litigate in workers' comp. You file a petition, you ask for a claim, and you could have 10 petitions on a claim. So we'll even talk about that, and you can see how that drops. So when I say petitions, that's the measure of litigation. All right, so let's see. Okay, so this is the first slide, which is basically, this is taken from the annual report of the Office of Judge of Compensation Claims. I think this is pretty dramatic, but you can see from 92 to 93, the increase in petitions, and that was what was causing rates to go up, claim costs to be outrageous. And you can see in 2003, 151,000 petitions were filed. Now, and I highlighted, not very well, but 03 and 04 were, of course, the reforms. So then you see in 04 the dramatic drop quickly in 1 year. And then as you follow the graph down, you'll see by the time we got to 08 and 09, it was down to, what, 72,000, almost half. But what happened in 08 was we had the Emma Murray case, threw it back, said it's, put the hourly fees back in. Fortunately, in 09, the legislature fixed that. But you can see in 08 and 09, that little tick up. And the tick up was because hourly fees were back in. Legislature, with some good friends of the industry, fixed that, and of course, then you see the drop again. It gets as low as 58,000 petitions, but then guess what happens in 2016? And you can see it pop up. Everybody's probably aware of the Castellanos case, which again put hourly fees back in. So this graph literally will tell you that if you eliminate hourly fees in a one-way attorney's fee statute, you have dramatic results. And then you can see also, though, that the tick up was pretty consistent, and 22 we're only at half of what 2003 litigation. I'm not even going to say petitions, I'm going to just say litigation. The litigation was half of what it was in 2003, even with the Castellanos case. And we'll talk a little bit more about that. But, and I can give you some percentages. It was 66% up, it came down 63%. Also, over that period of time, we had a drop in rates of over 60%. Rates dropped during that period of time. I think at one point it was up to 67%. Cumulatively, through this whole period, if you add and subtract all the, it's a minus 71 rate reduction in workers' comp rates. So anyway, it works, and it's immediate. At least in workers' comp, it's immediate, but I would guess that in other lines, and I know one-way attorney's fees are an issue. Quite honestly, they were an issue. We fought hard back in 03, and we told them, if you pass this bill, rates will come down. They didn't believe us. They don't believe any of us really when we say that, but In any event, they did. So we can learn a little history from that. All right, so this is important too. You see the line, the red line, which is new cases. And the blue line is petitions. That's the litigation measure. So a lot of people were saying, oh, you're going to take away the hourly fee. Nobody will file cases. Lawyers won't be available. But if you see that red line, after 03, it starts to drop down, right? And it just stays flat. So even if you look at the 2015-16, when the Castellanos case came out, it's flat. What does that mean? Cases were still being filed. Lawyers were still taking cases, and they were still filing. Now, there is a couple components to that, but I would suggest to you that eliminating or attacking the litigation component in one-way attorney's fees does not necessarily eliminate lawyers from the process, and that injured workers, homeowners, whatever it is, will still find a lawyer, and they will still get what they need to get relative to their claim. So let's see. So anyway, okay. I'm trying to go fast. This is important too. So I talked about 2016 and the Castellanos case and said, okay, you can go back to the old way of doing things that we cured in 2003, and you can start charging hourly rates again, which meant if you filed 6 petitions on one case, you basically could have gotten 6 hourly fees out of that. And so it just would bankroll. But the interesting thing is that the First District Court of Appeals in 2016 also came out with an opinion called the Miles opinion, which said it is unconstitutional to restrict what a lawyer and his client can agree to in workers' comp. Historically, retainer agreements always followed the statutory schedule, which was 10%, 15%, 20%. It moved over time. So everybody was signing retainer agreements with that schedule. Somebody wanted to contest that. Long story short, court said they can charge whatever they want. You know, claim injured worker and a lawyer can agree to 40%, 30%, 25%. We've seen all of those percentages. So what's important about this graph is that you'll see in the middle graph, that's the hourly rate, that's the litigation part. It stays flat. It's at, still, it was like a 1% decrease ever since the Castellanos and Miles case. So you with me? In other words, Castellanos says hourly fees are good. Miles says you can take from your claimant anything you want, up to the Florida bar rules. But if you see that blue line, that is what lawyers have been taking out of the settlements that are entered into for their injured worker. And if you'll notice, it's going up. Hourly fees is staying flat. So what's happening? It's gone up 58% how much money they're taking from the settlements. So in effect, the Miles case, put back the goal of the 03 reforms by saying it's more lucrative. They took the incentive of hourly fees back out again, indirectly. You with me? In other words, why mess around with the hourly fees and over-litigate claims when I could settle the case and get my 30% out of that? So indirectly, the Miles case was kind of a blessing to keep that elimination of the incentive. One was direct, one was indirect. And so, again, I think this is a pretty good example of how, through legislation, if you attack the incentives to litigate, whether it's hourly fees, whether it's trumped up policy demand for settlement with all sorts of conditions, all of those things that incentivize litigation, it will make a difference. And let me finish on this note. I'm sorry if I'm going too fast, but we're going to cover some stuff. But I didn't have this slide up there. But here's the interesting part of what's happening since the Miles case. The lawyers in 2022, I am a lawyer. I was around in '03. We dealt with this stuff. We got yelled at and everything by everybody. I got called all sorts of names back then. But in any event, the lawyers in 2022 collected $237 million off the comp system. This is a significant number. Over the last 6 years, it averages about $219 million. That the Miles case has now shifted from over-litigating cases to simply settling cases, which is not bad. It's a good behavior. Settling cases and take the money from your client. So I think all of these things, and there are other graphs in that and other things that you can look at in that report, but I would just tell you, I mean, it's pretty clear that our experience in workers' comp, as much as they say rates won't come down, they did. And they did immediately. And so I think the bottom line takeaway is you got to deal with those incentives. And don't listen to anybody who says they won't be able to get a lawyer. The claimant won't be made whole. They will. They'll get lawyers, they'll file cases, but the litigation component, the incentive litigation will be reduced. So I hope all that makes sense. I think if we have some time, we can take some questions, but anyway, but I appreciate your attention, and I hope that I actually depicted what happened in comp, and I think we can learn a lesson from that for other lines. So at this point, I'm going to turn it over to Lisa Conley, who will talk to you about present-day market issues.
Good morning, and thank you for being here. And as Brewster said, I'm with FCCI Insurance Group, and for those of you who may not know who we are, we're a commercial property and casualty carrier. We only write commercial lines, so we don't do homeowners, personal auto. We write lines like commercial auto, commercial property, commercial general liability, surety, and obviously workers' compensation. We write in about 20 states plus Washington, D.C., but I think what's relevant to this conversation here today is our roots. We were born out of market necessity. We were started by a group of construction contractors in Sarasota, Florida, that could not get workers' compensation due to market conditions. So we started as a workers' comp self-insurance fund back in 1959. And obviously we've expanded over the 60 plus years since then into other lines in other states. But workers' compensation really has been our roots. And as Tom said, there's been a lot of changes over the last 60 years. And he's talked about the reforms in the last and the impact on the market in the last 20 years. So where does that bring us to today? And as Tom alluded to, over the last 20 years, we've seen rate decreases every year in workers' compensation other than law-only changes. And carriers have also, though, been making an underwriting profit. So for every dollar we collect in premium, we're paying out less than $1 in losses, expenses, and dividends, which is where you want to be as a carrier because you want to have surplus in order to pay future claims, because for comp is long tail line, so you can be paying claims for 10, 20, 30 years. So it's critical that carriers make money. It's important to marketplace stability. And there's a lot of reasons for the good fortune and the healthy state of the market we're seeing today. And Tom talked about some of the reforms and the impact there on rates and employers, which is key. We're seeing a downturn in frequency for a lot of different reasons, claim frequency. And so where does that leave us for the future of comp? Well, I mentioned that Florida carriers are making an underwriting profit, but we're not necessarily seeing that throughout the rest of the country. We're seeing prior claims be more profitable, but current accident year claims not quite as much, which may indicate a turn in the other direction. Claim frequency is starting to tick up a little bit. If you've looked at the FCCI rate filing, we've seen decreases in frequency, but the last year we've seen a little bit of an uptick. And then everybody's favorite topic of the day is inflation, right? So work comp is very sensitive to both wage inflation and medical inflation. And it's more insulated from social inflation, those large jury awards, because there's benefit, right, to having the statute dictate what the benefits are, and the statutes dictate what the medical costs are. because you can inflate medical costs all you want, but you're only getting paid what the fee schedule says you're getting paid. So there are no letters of protection in comp. I think the first line to see that inflation hit was auto physical damage. So if you tried to get your bumper fixed in 2021, you'll understand what I'm talking about, right? It was hugely expensive and you had to wait a long time for those auto body fixes. The next sort of area to feel that really was construction costs. So that's kind of drove the severity in property claims. But medical inflation has been running kind of behind those lines, but the industry does think that that's going to accelerate. And if you listen to the earnings calls of, large public companies and carriers, that is what they're concerned about, is that medical inflation starting to take off. And if you think for work comp, about 60% of the benefits are medical costs. So managing that cost and delivery of medical care is really critical to sustaining a healthy marketplace. So having those solid benchmarks, an agreement in advance of what's reasonable, the fee schedules are key for medical. Keeping the attorney's fee cost drivers in line are critical as well. And with the graph that Tom just showed, those attorney's fees, a JCC found that those were reasonable. So even though the lawyers can charge what they want, there's still that natural, I don't want to say natural, but there's still that parameter and guide rails of what an attorney can charge that is not present in other lines as well. So comp is a little bit unique in that it doesn't have some of those pecuniary drivers that other lines have. So with that, I'll turn it over to David for his commentary on the line.
All right, well, thank you, first of all, and good morning to everybody. It's good to see you all. I think this is the first time I've had an opportunity to chat in this capacity since I left the office at the end of December. So in that spirit, thanks to the AIF for having this event. Thanks especially for having it on a Monday. My golf course is closed on a Monday, so it made it a lot easier for me to make it down here. Appreciate that. So I'll just offer my thoughts as just some guy now. So just by way of a little bit of background, you all probably remember in 2016 going through the process to pick a new insurance commissioner. And before that, I'd been at the office and kind of grew up in the PNC space and did a lot of homeowners work and did a lot of auto insurance work. But every time I met with Gary Guzzo, he would remind me at the end of the meeting, don't forget we've got these 2 Supreme Court decisions that are out there, 3 actually. And they're going to decide on them someday, and they could be either really good for us or really bad for us, and we're just not really sure. So fast forward to April the 28th, 2016, I'm driving from Tampa to Tallahassee, and I'm going there to interview with the cabinet the next morning to try my hand at being the insurance commissioner. I'm making that drive. I'm trying to figure out what in the world are they going to ask me about tomorrow morning. And in the middle of that drive, I got a phone call from somebody, and they said, hey, just as an FYI, the Supreme Court just ruled on the Castellanos decision the day before I interviewed for the insurance commissioner role. And so I thought, well, that probably clears up what they'll ask me about tomorrow morning. And so certainly Attorney General Bondi had a few questions about those decisions. And I've always wondered to this day, does somebody on the Supreme Court have some kind of sense of humor where they thought, let's drop these decisions out there the day before these guys interviewed for the insurance commissioner role? But nonetheless, my first several months, I would say, on the job were spent dealing with the Castellanos decision, talking with a lot of stakeholders in the workers' comp space, FCCI especially, who came in and did a law-only filing. You guys might recall that. I think they asked for a 19.5% rate increase, if I recall correctly. The challenging part for us at the office with that was that it was a law-only filing and not an experience filing. And so in other words, we didn't have a whole lot of data to try to figure out what's going to be the rate impact of the Castellanos decision. There was also the Westfall decision in there also, but I think the Castellanos one probably is the one that we thought was going to have the biggest impact because it dealt directly with attorney fees. So ultimately, after going through the hearing and everything else, we approved a 14.5% rate increase. And I remember at the time, I cautioned everybody and said, you know what, we're doing 14.5, and I know that that's painful, but I'm not sure that that's enough. And I would brace yourselves for us to come back in coming years as we get more data on the impact of this and probably raise rates even more. That's not might have been the first time I was wrong as the insurance commissioner, but certainly not the last time I was wrong as the insurance commissioner, because over the course of the next several years, we actually approved some pretty sporty rate decreases. I was always very excited about that, but also very surprised by that. Also very thankful for that, because when I met with stakeholders that were accusing me of always raising rates, I could always point to the workers' comp space and say, not always, we're lowering them sometimes. But there's an interesting thing about all of those rate filings that we approved the rate decreases for, because the question that we always had for NCCI is, hey guys, we just approved the 14.5% law-only rate increase, and now you're proposing a rate decrease. Are we going to get accused of overshooting the mark when we did that law-only filing? And they said, no. Look at the underlying data here. Somewhere out there in the public domain in these rate filings that NCCI does, they do a chart where they show year-by-year experience in the rate filing of litigation and attorney fees and the impact that that's having on the rates. And so there's a good news, bad news sort of situation with this data point. The bad news is that it does appear that experience is having an adverse effect on the rates in Florida. And so you can see in these trends that the Castellanos decision is having a bad impact on the trends of litigation in the workers' comp space. The good news is that is being entirely more than offset by workplace safety enhancements. You can see the frequency and severity of claims are dropping more than that is increasing. Shortly after the Castellanos decision in I think the 17 legislative session, I think maybe even the 16 legislative session, there were a couple of members of the legislature that wanted to take on this issue of workers' compensation insurance. We'd always show those data points. Here's a motivating factor why you should do that. Well, with everything else going on in the insurance space, with the property market doing its thing, with everybody talking about repealing PIP, and the fact that workers' comp rates were going down, there just wasn't a lot of motivation to really take that issue on. But make no mistake, if you look in those slides, I tried to find them this morning and couldn't track them down, there is some data that NCCI has been tracking since 2016 that does show an adverse effect from the Castellanos decision. And so I think as we continue to go forward with workers' comp rates, it will be interesting to see how these issues of frequency and severity of claims, how those trends continue, and whether or not they continue to offset some of the litigation experience that's in the filings. You know, this has kind of been an interesting situation, because these workplace safety trends that we saw, I'm saying workplace safety, I think we commonly attribute the decrease in frequency and severity to enhanced workplace safety. These were taking place before the entire world went to work from home. So these were actually people going into the office. And so as a lot of people are bringing folks back into the office after COVID-19, it'll be interesting to see if those same types of trends in frequency and severity of claims continue to persist and continue to offset the litigation experience that we're seeing in the filings. You know, one of the other interesting things about the workers' comp space that has an impact on rates is the way that workers' comp carriers do their reimbursements. I was fortunate enough to serve as the chair of the 3-member panel on behalf of CFO Petronas, and one of the things that we did was the reimbursement manuals. That's a challenging process for anybody that's sat in the 3-member panel meetings. Workers' compensation is one of those areas of insurance that brings out all of the stakeholders. Everybody comes with their opinions, from the business communities to the medical communities to the insurer communities, and everybody has a different thought on what the reimbursement manuals should look like. And the challenge with the reimbursement manuals is that once you decide what they should look like, what the reimbursements should be, DFS has to go through the rulemaking process. I mean, if you've ever been part of the rulemaking process, it's not exactly an easy process to get through, especially when you have a contentious issue like workers' comp reimbursements. And then to add to that, any time the reimbursements have to increase, there's a state law out there that says that if it adds $1 million or more of expenses into the marketplace, the legislature has to ratify that. And they have not done that except for one time in the past however many years when it has to do with an increase. And so a lot of times we'll see reimbursements go down because they don't necessarily have to be ratified by the legislature, but when reimbursements need to go up, that's a little bit more challenging. And you can see in some areas of workers' comp, in particular, I think inpatient hospital, ambulatory services, and I think drugs. If you look at the amount that Florida reimburses compared to what other states reimburse, we're actually a lot more. And so there's an opportunity, if the legislature desired, to look at ways to potentially continue decreasing costs for consumers in case the frequency and severity trends don't necessarily continue. Workers' comp was one of those areas that was extraordinarily important to us at the office when I served as commissioner, and I know it will continue to be. The challenge that I think we have with respect to workers' compensation insurance is that there's so many other areas of the insurance industry, namely the property insurance market, that are having their own sets of challenges. And when you look at the workers' comp market and you read our workers' comp, well, I keep saying R, when you read the OIR's workers' compensation report, you see it's a competitive market, it's not a concentrated market, rates are going down. It might not necessarily be getting the focus that it needs to be. But the good news is that some of the issues that I think are plaguing the property insurance market and to some degree the auto insurance market, I think fixes there, if they're general enough and broad enough, could have some favorable impacts on the workers' compensation part as well. That's about all I can remember over the past 6 weeks. So I'll stop there and just say thanks again for the opportunity to chat with you all a little bit this morning. I think if there's questions or anything,
Well,
I'm not sure how you want to.
Following up on the reimbursement, the three-member panel, there are some things out there right now that are being contested. Some have been very polarizing. You know who the players are. But I would say that if you were going to look at, comp right now, it's not in a bad place. But it doesn't mean there are some things that we can't look at and see if we can do differently. I'll just throw out some things: physician dispensing, compound medications, and usual and customary charges from hospitals. Those are the areas that sometimes these rules right now are probably dealing with. And so to the extent there are still some remaining cost drivers, but probably look at a little bit more on the medical side. It's not that we don't have some challenges to tackle, but I would say on the indemnity side, everything's pretty good. Medical side, it's a matter of, I think, tweaking some of those things, maybe going to a formulary like Texas does, where it's a closed formulary and doctors can only prescribe certain medications. So there's still some things out there to look at and see if we can do better. But other than that, and maybe this is, you guys all can't see that. This is
That's a great chart that shows what's offsetting the litigation interest.
Right.
There's I'll describe it to you. It's one of those actuarial charts. It's bar charts, and each year has got like 4 or 5 different bars on it. And I'm going to try to describe this. I'm certain I'll get this wrong, but I think what they're looking at is for each year, what is the reserve development on some of those litigated claims. And so you can see in years post Castellano, there's a significant amount of development, and it's getting worse. But we've been fortunate that some of those severity trends have prevented that from causing rate increases opposed to decreases.
Yeah, and this really just shows, and you guys can't see it, but it does show that the loss ratios on medical and indemnity were all going down. Severity and frequency are going down. But all of a sudden it flattens out again around 2016 because of Castellanos and probably Miles to some extent. But then it starts dropping off again because frequency has been a big issue. So anyway, we have only a minute or so left. I did want to say that even prior to Commissioner Altmaier, we used to always have this debate with why nobody wanted to give any more than a 0 profit and contingency in the rate filing. So in any event, and Brewster, we went quick. I don't know if there's any questions out there that anybody has about our wonderful world of workers' compensation. If not, I think we're...
I've got one for you, if you don't mind. Do you foresee or see any certain industry sector that you're seeing more claims coming out of? As we move forward, and more people moving to Florida, more homes being built, more buildings being built. Do you see any industry sector that is having increased claims? Now and then into the...
Well, maybe Lisa, you could talk, because FCCI is a big construction rider on the sub side.
Yeah, and I don't know that we're seeing any in particular industries. I don't know about that, but we are seeing auto is always a problem, because even if it's a comp claim, most of the comp claims or a lot of comp claims come out of auto claims. People are driving around in the course and scope of their work. And so just with the increase of people on the roads since COVID, people are driving more aggressively for whatever reason. So we're seeing a lot of claims through auto. And like Tom said, we do a lot of construction work. So we always see a lot of construction accidents, and we try to, tackle those through workplace safety programs, return to work programs, and, again, having those, tie-in requirements for people falling off roofs, having auto safety driver training for policyholders. So the loss control piece in comp for carriers is key.